Intellectual property in cyberspace, cyber ethics, morality, and law in cyberspace. Chapter Overview. As technology has progressed over the years, the laws have not adequately kept up. As a result, there is a lack of balance between the rights of users and property owners. This chapter explores the need for legal protection of intellectual property, legislation over the years, and the different fields in cyberspace these laws relate to. What is intellectual property? Spinello defines intellectual property as property which consists of intellectual objects such as original musical compositions, poems, novels, inventions, product formulas, and so forth. Because intellectual objects are abstract, they are harder to legally protect. The key is to make a distinction between the idea and its expression and to copyright the expression, not the idea. Legal protection. Intellectual property dates back to the U.S. Constitution. Copyright laws give authors the rights to their own work and rights to make copies. Patents give legal protection to physical objects like machines and inventions. Trademarks are words or phrases or symbols that pithily identify a product or service. Some recent legislation is the Digital Millennium Copyright Act, or DMCA, and the Sonny Bono Copyright Term Extension Act, or the CTEA. The heart of the DMCA legislation is its anti-circumvention prevention, which criminalizes the use of technologies that circumvent technical protection systems such as an encryption program. Enacted in 2004, the CTEA extends the term for copyright protection for 20 years. The 1976 Copyright Act established the term of life of the author plus 50 years for an individual and 75 years for corporate authors, in other words, companies such as Disney. The CTEA extends these terms by 20 years, so protection for individual authors is now the life of the author plus 70 years, and for corporate authors, 95 years. Issues for the Internet and networking technologies. The revolutionary distribution method of the MP3 has propelled the music industry into chaos, but it does have certain key advantages. Authors, composers, and performers can publish and distribute their music online without the assistance of recording companies. This low-cost distribution method creates benefits for both the creators of music and their customers. However, the ability to easily share downloadable files may lead to many copyright issues. Some additional issues are software patents and open source code, digital rights management, business method patents in cyberspace, patents in smartphones, and domain names. Can portions of books be made digitally available without violating copyrights or other moral rights of authors? What is the optimum way to sell ebooks to ensure adequate compensation for authors and publishers and to stimulate innovation? In conclusion, the laws relating to intellectual property need to be revised. There needs to be a balance between free use and property rights, and it is just as dangerous to make the Internet a copyright-free zone as it is to overly protect the property rights of owners.